welcome to the 5th season of the PI Show. My name's Harry Nowicki. I'm a solicitor with Tony Carbone.
Welcome, viewers.
And we've got a very interesting season coming up, Tony. I can't believe
5 seasons.
5 seasons
Welcome back,
gone.
Harry. I mean, it's been very entertaining so far.
It's been amazing, and we've got bigger and better shows coming up with some very exciting guests. Tonight, we'll start off with what's in the news.
There's been an interesting story, Harry, about a young Vietnamese worker that got injured at a strumpet factory. He was working on these steel pylons that they use for roofing, and it was a pretty big verdict. He got $1.1 million. Now, the interesting thing about this case is that the parties just couldn't agree on the facts, and there was experts involved, and we've got the expert here today who was in that
funny
case.
you should say experts were involved. We've got one of Australia's leading experts in this area, Mark Dorman. Welcome, Mark.
Thank you, Harry.
Mark has a very extensive CV. He started off in 1976.
That's right.
Doing reports, and you've covered the whole gamut of expert evidence throughout Australia, and you've been overseas, I believe, to China as well.
I have, yes. No, I've been busy for quite a few years now as an engineer and ergonomist, doing safety work as a consultant and giving opinions in court.
Well, Harry, just curiously, on the issue of this case, they seem to have agreed on the figures.
Yes.
They agreed on the amount for loss of income, and that was pretty big. It was over $800,000, Harry, and the only issue that was fought was their negligence.
Yeah,
and
whose fault?
You played a big part in that, didn't you, Mark?
It seems so in the end. There was a lot of argument about what actually happened and the true facts of his work and how he did it, and that took quite, I think, 3 days in the end to argue out until the court was satisfied that they knew what this man did, and then the jury gave him a unanimous verdict.
It's a bit disconcerting. It takes 3 or 4 days to work out what exactly happened. I
think the starting point was, I think, Mark, you went out to the factory and had a view.
I did.
So the view is an important part of the whole process.
Yes.
And he'd stopped work by then, so you couldn't actually see what he was doing, but you saw other people, in the same situation.
That's right, and we could see the workplace there, and as is often the case, he explained certain changes that had been made, improvements that the employer had made, and made it plain to me what the true situation was when he had worked there.
Well, you reconstructed the events that led to his injuries, is that correct?
Right. That's right.
And there's a big argument about how much weight he had to lift.
That's right. This is often the case in lifting matters in factory accidents because, for example, a person might be thought to be lifting relatively small weights, but in fact, the way the workplace is set up or something peculiar about its shape, or in this case, some small obstructions on a workbench, meant that he actually had to do a lot of lifting, and the employer either didn't know or wouldn't agree that that was going on. When that was established, we had some serious lifting going on, and away we went.
Mark, it was a lot of lifting, but very subtle sort of lifts. Is that right?
Yes, it was a lot of lifting. It was highly repetitive, and the repetitive aspect was very important. Once again, many jobs which have fairly small forces or small weights, in fact, because of their repetition or the awkward posture or the long reaching that's involved, cause high stresses on the spine and are responsible for injuries. This was one of those.
And Mark, you gave evidence in court. I think you were cross-examined.
I was.
And it was a jury trial.
Yes, 6.
And that seems to me to lengthen the time people, have to give evidence.
It does, because everybody's got to ask questions, cross-examine, understand. Even the judge might want a few questions answered. The jury might put questions up in writing that you have to answer as clearly as you can until everybody's happy and the court can do what it has to do.
Were the only expert called, Mark, or was there one called for the defendant as well?
No, there were 2. Another engineer, he was called by the other side, and curiously, I think we both had different information, different facts for quite a while, and that was leading to different opinions. If the facts had been shared earlier, I think we would have converged more quickly.
And tell me this, did the jury go out to see the work site itself?
Yes, they did, and they all went to have a look, so they knew what we were talking about. They understood it when the injured worker himself gave evidence, and it was a good thing that everybody saw it, because there's nothing like seeing a workplace to properly understand just how it is. I've never been on an inspection, however trivial, that wasn't worth it. You always find something
Harry,
out.
it must be pretty disconcerting to the public at large that you've got 15 days of a trial to determine what the facts of a case are. It's very sad, isn't it?
Oh, no, I think Mark said 3 days to determine the facts. There were other legal issues
And this case
involved.
ran for 15 days.
It ran for 15 days, but there would have been medical evidence. My understanding is the worker had 2 back operations that failed.
Yeah, he was using a walking stick at the age of 31, so it's pretty sad.
He was a young man, he had a lot of life in front of him, he had a family, and he worked with his brother. And
he gave evidence too, I
He
believe.
did.
The brother gave evidence, and I think, as I say, the pain and suffering damages was $250,000, and the economic loss in the future was just over $800,000.
It's one of the biggest verdicts we've had in Victoria, because it was over 1.1 million, I think.
Yeah.
One thing I thought of during the case and beforehand was, it was another example to me where people whose first language is not English didn't, I think, really get listened to carefully or trained in their own language or looked after in a way that they would fully understand. I think those workers, like so many, could have told their employer what was wrong and could have given advice earlier which would have prevented it.
Well, there was evidence, Mark, that he did complain to his bosses and they didn't really take heed of his complaints.
That's true.
And I guess there's always the argument, us lawyers see, that people are too scared to complain as well, because they're going to lose their job, or they're going to...
He's got a mortgage, he's got a family, he's got one job, he doesn't want to lose it.
Now, another case, just going back, again, I think cases are interesting, is the lacrosse player who fell in a Hawthorn block of flats.
That's right.
And I think there was a group.
a lot of defendants, Harry.
Well, no, there's a group of people who went out drinking.
They did.
4 or 5 of them went back to a flat, and there was sort of horseplay on the stairs.
On about the third story, I think.
The third story, and then the plaintiff stumbled.
Well, someone
pushed
hit him.
Well,
and he's bounced off.
I'm not 100% sure what happened, but
Well, he went backwards against the balustrade on the landing.
And fell 3 stories down.
Poor devil.
And ended up in a wheelchair. I think he was about 25, and I think he was captain of the Australian lacrosse team.
Yes.
So he was a fit, healthy young bloke.
Yeah.
You know,
Had 25 years of age.
25 years of age, and then ended up in a wheelchair.
He did.
Now, the plaintiff sued a lot of people. I think there were 10 defendants, and you were an expert for one of the defendants.
Yes. In this case, the railing was found to be fractionally too low. It was less than the Building Code of Australia prescribes for the height of a balustrade, and that's the law, and they failed on that. And then it was demonstrated that when people get pushed back against a balustrade at that height, your body reacts, and it's easy to show how you'll tip over, and that's just what happened.
Mark, is it fatal to a defendant or a builder or an architect for the balustrade to be lower than Australian standards or building standards?
It can be, only if that causes the accident, only if it's directly and unambiguously related to what then happened.
And I think the judge found that. But look...
we're going to have to go to a sponsors break, Harry and Mark, so okay. I want the viewers to keep watching. Don't go away, we'll be back very, very shortly. Thank you.
Thank you.
Thank you.